Welcome again, everyone. If you've just joined us for this webinar, thank you so much for registering. Thank you so much for being here today. My name is Silvan Jongerius, and I'm the managing partner at TechGDPR. And today I'm joined by Stewart Haynes, who is the former Information Commissioner of the Isle of Man, and has recently joined us at TechGDPR as a senior consultant. Now, one of the skills that Stewart, and maybe you can elaborate a little bit on your relevant experience to DORA as well, because there's so many things that you have done in your career that all touch on DORA, and that's what we'll be talking about today as well. But one of the specific interests and skills that Stewart is bringing into TechGDPR is experience with similar regulations, frameworks that are immediately transferable to DORA, and this basically led us to also invite Stewart for this webinar and in general to join us as an expert on the matter. Today we have a number of high-level topics that we like to address, but in particular focus on how is DORA so important and relevant for decision makers and leadership within organizations. Before we get into that, Stewart, maybe you can elaborate a little bit on your relevant experience. What have you done that touched on similar aspects and frameworks as DORA to help put this into a good position for our viewers?
Thank you, Silvan, and good morning, good afternoon to everyone who's tuned in. Yes, so my experience is kind of a learning journey, if you like. So I sort of saw the passage of DORA before it became enacted and after so, and sort of as a data protection person, kind of really observed the sort of integrity principle of GDPR within the legislation. So it's really kind of a huge drill down on that principle, and it really interested me to kind of see to what extent that went to and has gone to, and to a good end, I think. The legislation sort of standardizes lots of different things, but particularly in industries where consumers are most affected. So I took a keen interest in the legislation, the passage of it, and also the kind of the ever-evolving guidance around that over the 2 years. So DORA was enacted 2 years ago yesterday, I think. Yeah, 2 years ago yesterday. So it's enforceable from today. And we wait to see how NCAs, which, you know, there'll be a few sort of acronyms in here. NCAs, National Competent Authorities, which are generally sort of national banks who kind of enforce regulation, how they act and how they will act. But it's go live from now, right?
Right. Let's maybe talk about that. So DORA has been is officially in force as of today. That's also such a great day to be running this webinar.
Funny that, right? Funny that,
isn't it? Yeah. Maybe what we can look at, like what is DORA actually?
Sure.
So what is this regulation? What does DORA stand for?
Sure.
And also what is the scope of applicability? Which companies need to care about?
Sure. So I imagine people tuned in will have a knowledge, but we'll take it from the basic, right? We'll take it from the sort of overview. So DORA is the Digital Operational Resiliency Act, right? So it essentially standardizes, or sort of it puts into a legislative framework standards for operational resilience within the financial services sector, which is made up of 21 different sectors, and also companies that supply into those sectors that might be deemed ICTs. So an ICT is, or critical ICT is, an information and communication technology app or a company, essentially. And really kind of what DORA does, it has 5 pillars, 4 of which are mandatory. And it's really about how you prepare for risk, how you respond to risk, how you mitigate risk, prior to the risk crystallizing, and then how you engage going forward with regulators and how you report that risk. So there's a lot to, I don't really want to equate it to GDPR. It's not as, I mean, it's similar in terms of the integrity principle I mentioned, but it doesn't have kind of a dual responsibility for a DPO, for example. So there wouldn't be the expectation that a DPO would take up the project for implementing DORA, because DPOs should be separate from processing activities and decisions about what happens around different processing activities. But to give you some sort of scales, I mean, GDPR was 11 articles and 99 chapters. Sorry,
The
99.
other way around, I guess. Yeah.
Yeah, 99 articles. So this is 71 articles and 8 chapters. So to give you some sort of context of size, it's a huge piece of legislation which probably is underreported in terms of, GDPR came out, everyone was, aghast at the responsibilities that companies, had to kind of abide to. But with DORA, it's something that's sort of slipped in, and it's kind of in the UK actually that there's equivalent legislation, so people are already being fined in terms of personal liability in the UK for similar acts that we've got. But actually, in terms of, if you look at the sort of size of legislation, it's sizable. It's sort of 3/4 of GDPR, so a lot to
Right.
consider, lots of detail.
And I guess, like, I mean, I remember all the panic around GDPR back
Hmm,
in
hmm.
2018 before it came into force, right? And we hardly have seen anything like that.
Sure.
Or I'm sure there's a bit of, like, I mean, there's a lot of noise on social media, but there's no real panic. It's not really in the media. So I'm thinking that you're quite right that this is underreported. Maybe quickly getting back to the scope of applicability. So what kind of organizations does it specifically?
So essentially, it's termed financial institutions, but that, as with any industry sector, has subsectors. So there's 21 sectors that are affected by this. So, however classified by the EU, they range from pension companies to banks to cryptocurrency companies to all manner of sort of sectors. I think one of the things I would sort of make the most kind of point on is that companies really need to know whether, like, before you talk about, implementation plans, you need to know if you're in scope, right? So if you think you're connected to a sector, so if you're in that sector, you're likely to be in scope. And if you supply into that sector, you're likely to be in scope to a different degree, but you're likely to be in scope. So even if you're in scope and you supply into a company that's in that sector, it's likely your contracts will change. It's likely you will hear about DORA, because DORA will be similar to when GDPR was sort of came into force. Everyone had to do DPAs, data protection, data processing agreements, and this will be similar in this respect. So expect kind of renegotiation of contracts, expect different clauses, expect your legal team to be engaged, because this is where the legislation puts responsibilities on providers to do that.
Right, and providers then also include providers of, like, technical systems, right?
Sure. Yeah.
So if I'm providing a software to financial institutions or
Mhm.
financial companies, then I would need to probably renegotiate these contracts with my clients. I need to make sure that I'm ready for DORA, and there's also liability on me under DORA.
Yeah, I think even if you think you're, say you thought, well, I'm outside of those 21 sectors, and I think we've got it on our website, the sectors that are in scope, directly in scope. If you think you're near those, I would suggest really going through kind of a process of determining whether or not you're actually in scope or not, getting that legal surety that you actually are within scope or not. Because if you think you're not and you are, you're likely to be kind of you're likely to have not a good surprise if something goes wrong, because you haven't actually factored into the equation that you were in scope or not. So I definitely suggest kind of getting some sort of advice whether or not you are in scope or not.
Right. And you already mentioned, like, this is a significant regulation, right? It's 25% of the GDPR. in terms of lengths and articles. And probably if companies haven't done so, I mean, there has been a bit of time to prepare. It's not something that has been introduced very recently. We've been leading up to it. But there's significant work to be done, right? Is there
Very
anything
much so.
to say about the amount of work? Of course, it depends on the company, the complexity, the scope, like everything. But is there anything you can say about it?
Yeah, I think what I caution against is my experience. I don't know what your experience was of GDPR. I think it was given to someone doing a full-time job as a project, another thing to do. And this is a sizable amount of work, and it's an organizational piece of work, and it's a program of work, and it should be sort of overseen by your most senior leaders. So your
Mhm.
senior management team should have oversight of this program. So to kind of maybe to learn some lessons from GDPR from certain companies who perhaps went to the IT team and said, "Oh, look, we've got this now. It's GDPR. It's another piece of regulation." Actually, don't do that. Look at the obligations you've got as a company. Look at the liabilities you've got as a company if you fall foul of those, and really understand what you need to do. And I think, I mean, buy-in is a slightly sort of overused term, but actually buy-in in these sort of situations is crucial. It's crucial for if people on the call are senior managers, if they're directors, great, take this away, take it to your meetings and understand kind of the scale and scope of what you need to do. If you're kind of an IT leader, make sure you go to those leaders and you say, this is what we've got to do. This is a huge piece of work. And so before you even get to like a gap analysis stage, I would say make sure you're having those board level conversations where this is discussed, it's discussed robustly. And for many organizations, this won't, to be compliant, won't be a sort of it will cost money because lots of different companies are set up differently. And what DORA does is it standardizes how you sort of stand back up systems really that have gone down. So if say you use a particular supplier, for example, that you might be contracted with for 3 years, if they don't meet the grade and you can't renegotiate the contract, you might have to look at a different supplier. So that might be someone you use. You might be a bank who use a different application to operate your ATMs, your cash points, right? So
Right, right.
something like that, something so critical, and this is the thing I think about the sort of the critical element is it's really it's really sort of understated how much you need to understand what systems are critical to your business in terms of the act, not what you think is critical. So, if you work for, you might be on the board, you might think,
Mm.
my high risk system, my HRIS system is critical to this order. It's not critical in terms of DORA, right? So those sort of things are not in scope of DORA. So you really need to have the best advice about what systems are in scope, what suppliers are in scope, what services are in scope, as opposed to including things that aren't and maybe kind of going down the wrong sort of path as to what you need to do in terms of those systems or applications.
No, and that's a really good point, right? And it's a point that I made on LinkedIn this week. Is like, is it too late to get your ducks in a row in time for DORA? Yes, absolutely, right?
Yeah, yeah,
If you haven't done anything, then this is
yeah.
probably the time to get moving on it and get moving on it very, very quick.
Mm,
And a really good motivator, maybe, is that well, the fines under DORA are typically lower than under GDPR
mm,
to 2% of total revenue or 10 million euros. But there's a big difference, and that is that there's personal liability for board members, for decision makers, for directors under DORA. So the GDPR doesn't have this direct liability for
mm,
decision makers, but DORA has it, right? So
mm,
this in my understanding is like a really, really good reason for leaders and decision makers in these sectors, in these
mm.
sectors, to act on it and to take this serious. And where the fine structure of GDPR did not always have the intended result in my experience. I'm not sure how you see that as a former.
It's disparate, right? So
Yeah.
disparately applied, I would say. So
Mhm.
not consistently applied, and which creates confusion, I think, and creates kind of an imbalance probably. But I think with DORA, you're absolutely correct. And the legislation allows for countries to apply those fines. So it doesn't necessarily mandate that they need to happen, but it allows for the prospect of those fines to happen. I know in the UK that we had equivalent, I say equivalent legislation, similar legislation around resilience enacted previously within a year or so. So the Prudential Regulation Authority, I think, fined someone about £83,000 a person, I think a Chief Information Security Officer, for a breach. Similar, I'm not saying it's under DORA, but I think it's definitely the direction of travel for certainly the UK probably didn't want to buy into DORA, but actually created its own act and or legislation or regulations, and we've moved that direction. So we're already sort of finding people for personal liability. So it's definitely an interesting take, right? And I just
Mm.
really just if you're at the early stage where you haven't done anything yet, and this isn't. It wouldn't come as a surprise to you, all right, Sylvan, or anyone really. Business have a lot to deal with, a lot of regulation, a lot of burden. We understand that companies don't sometimes tend to look at things until probably the last minute-ish, I would say. And I think Redora is probably the same. What I would say is you really need to now have an action plan as to what you do. You can't do anything now. You can't do nothing if you sort of mean. So you need to start put at the very least before you even talk about gap analysis, implementation plans. You need to be connecting with your senior management team, sat at the table, explain the risks, explain the obligations, and make sure the board know exactly what's upon the business and what it might cost as well. It could not be cheap, right? So Dora, it might cost a lot of money for a lot of companies, or for some companies not as much. They might assimilate to the technical standards quite well, but for lots of companies, it will cost a lot of money. I think that's an honest conversation you need to have at board level around getting compliance, because I don't think you can sort of half achieve compliance. You might need to sort of potentially you might need to put three or four legacy systems that you rely on into being legacy systems, and I think that could cost a lot of money
Right.
for a lot of organizations.
Right. No, so what you mentioned already, like it's important for senior management to engage with this
Mhm.
in the last place, because they can be personally held accountable.
Mhm.
Fines can go up to, I believe, €1 million
It's a
for.
million, yeah. The legislation is a million. So I think for third party, so there's sort of a nuance, sort of you're in scope and then you're partially in scope, if you like. So for third party suppliers, I think the fine for gross misconduct, that type of thing, is like €500,000. I think for if you're directly in scope, I think key persons can be fined up to 1 million. Yeah,
That's significant. That's
massive, massive. It's a game changer really in terms of regulation to be personally fined.
And what you mentioned before as well is that yeah, I think we both agree. Many companies have probably looked at it, but
Mhm.
we're still going to see like a 30-40% maybe of the market that doesn't have this completely in order by the time it becomes active. That's normal. We've seen this more often, and yeah, that's just the reality of all the regulation that we have in Europe. On the other side, if you want to get this started, like I believe that much of it starts with senior management. Obviously, you need
Mm.
to buy in, they are personally liable. So there will be some driving force from that side. But what other positions do you need to get around the table if you want to look at DORA?
It, it's a hugely IT centric operation. So obviously, I would imagine any sort of reasonable company would their IT people would be aware of DORA through the EU. They would be aware of the sort of changes. I think really you kind of need to look holistically at sort of things like things that typically you might outsource, like penetration testing. Now needs to be threat-led penetration testing, which is more organizational. So that might take account of your data privacy framework as well. That might take account of holes within that or issues within different aspects of your company. So I think certainly it's an organization-wide topic. It's something that you really need to train your staff. You really need to be putting out. If you haven't done already, you need to be putting out communicators to your company employees about this, the obligations, the changes that are going to happen. I think with any sort of big legislation uh, change, I think it does it jolts a company, it jolts their processes, it jolts their operations sometimes, and I think you really need to sort of give the preamble on that to your employees. I think you really need to kind of make sure that people know what's coming down the track, and that might be huge changes in operations. I think really if you're not communicating it from the top down to all of your employees, especially if you work within a sector where your whole business is supplying into, say, for example, a financial institution, you really, I mean, for a financial institution, you'd expect them to have done it already. I would expect them to have done it already. For third parties, you think, well, you probably would expect it, but if you haven't done already, you really need to start training and getting buy-in and making sure. Silvan, you remember GDPR, there was lots of kind of stumbling blocks with that. People morally to it. There were sort of objections from a business point of view. But actually it had to come in. It was a regulation. It had to come in. It was something that needed to be kind of adopted. And it was, eventually it's kind of, we kind of course, we pushed the mantle on that. But this is similar. This is very similar. So if you haven't done already, you really need to start thinking about your internal communications and your training of your staff.
Okay. And in particular, what I'm curious about, how do you see the role of a DPO in this effort?
It's really interesting, yeah. It's really interesting. I've read, and I think I read on some of the comments that we had on, very good comments as well. Absolutely, I don't think DPO should be in any way responsible for this project or any sort of work to do with that project, which was your thrust anyway, Silvana. Obviously, we need to be separate. If you're a DPO, you need to be separate from any decisions about process activities and any determination about how data flows within an organization. However, having been a DPO and having been in companies where sometimes that information is quite hard to get and it's really useful information, I would say make sure you're upon those meetings, you're in those meetings, you're connected to the documents that come out of them, because there'll be a lot of leverage you could gain from the sort of substance, if you like, and I think the outputs. Make sure you're there to give your best advice as well. Make sure you're there to give your best advice around personal data, security, all those sort of things that we do. But actually, be that pair of ears. Be in those meetings. Make sure you're there. Don't sort of see it as something outside of your role. These are definitely the things that sometimes it might take you months to try and get the information you might get in one meeting, right? And get in there, right? And make sure you're there, make sure you're sort of engaged and very often it's those sort of the meetings you least expect will bear fruit, do.
And I think it's fair to say that for a DPO, this is also very much a two-way street, right? So on one side,
absolutely, yeah.
A DPO is a very valuable resource with a lot of insight in how the organization is processing data, not only personal data, mostly personal data, but not only personal data. And on the other side, it's also like a big security exercise. So the DPO has a lot to gain for data privacy and for the overall standing of the company. So I think it's valuable to be to be involved, and of course for the organization, the moment that something is touching on decisions that involve personal data, the DPO also by mandate of the GDPR needs to be involved. So it doesn't only it's not nice to have, it's a requirement.
We probably hope that sort of utopian sort of idea is that we're much more connected with IT than we were 5 to 6 years ago, and there's not those sort of blockers and those sort of I don't know that there were kind of, I would say, blockers. They were from whichever side. We weren't as linked up with IT as we needed to be, and I think that's changed. I think that's we have to be. They're the custodians of the data. We need to understand all about that data for our own purposes, and I think it's the same with DORA. I think you really need to just be aligned with your IT teams. You can't have conflict there. You need to be all on the same page.
Let's talk about the regulator. So maybe you can explain a little bit of how the landscape looks like? Who is the oversight responsibility with? How do different European countries deal with that?
Sure. So essentially, so the regulation of companies directly in scope is through national competent authorities, which is essentially central banks, really, of each European country. The ESA is the European Statutory Authority, so they kind of oversee the strategy and also certain different aspects. We probably won't go into the detail, but essentially, central banks will regulate businesses within scope. And for this being a new regulation, from my sort of experience as being a regulator, I think there'd be certain expectations that a regulator would have. So we're day one right now. We're day one from supervision, right? So say you have a ransomware attack tomorrow, or any sort of attack tomorrow, and you have nothing in place. You're aware of the act. You haven't done anything for 2 years. You really need to think, is that a good place for me to be in? Is that a good place for my company to be in tomorrow, if this happens tomorrow? And financial institutions are attacked all the time, as we know. Really, at the very least, you need to be thinking, we've done this prior. If we haven't, we need to start doing something now. So the very start of post your conversation with your board is to start a gap analysis and to start looking. So if you, for example, if you have a sort of tepid attempt at a gap analysis, that's really clear when you're a regulator, right? When you get similar to DPIAs, when you get a DPIA as a regulator, you look at it, you think, yeah, they opened one, that's fine, but they've done nothing. It's really clear, right? So it's really obvious to a regulator. The same will be true of a gap analysis, right? So you could have the document, have a fancy system. If you've done no substance or detail, if you aren't actively working on that, if it's not timestamped, auditable, and you haven't sort of put actions in that, then it's really clear. And it's almost like a sort of a aggravating factor to, it's good to have something, but it's almost an aggravating factor to have something that's a shallow kind of facade of what it should be, almost from a regulatory point of view. So if I was working at a central bank, something happened tomorrow, I'd got a gap analysis and it had nothing in it apart from the name, date, the titles, no sort of detail in it. I'd be thinking, well, they've gone through the motions here. They've not even tried to do anything. It doesn't fall anywhere, is what I mean, right? So once you get to the stage of a breach or scrutiny from a regulator, it's no good to just send in a gap analysis or a DPOA and we're
At
moving.
least show some effort, right?
Show some effort, but also show some diligence and show some
Yeah,
competence as well. So
yeah.
I used this is moving slightly off track to do with DPIAs, but I remember looking at DPIAs as the arbiter, right, for the Isle of Man and the data protection regulations there, thinking these are people who've been imposed, like, well, this has happened, and I'm supposed to swallow that. Like, I'm looking at it thinking,
Mhm.
is that really what you're putting in? Is that what you're submitting to me? And it's kind of, I think some companies think, oh, it's okay, we'll have a document, we'll open it, or we'll have a well, you need to be doing something about it, and the same is true with DORA. Make sure it's got substance. So really, you need to commit to it. You need to actually do some of that, and you need to do it on an ongoing basis, similar to the concept of ongoing compliance with GDPR. The same is true with DORA. It's not one
Yeah.
stop. You don't. It's not a line in the sand, and 3 years later you do something else. It's very much. It's iterative. You need to keep doing.
Let's maybe have a look at one important thing that you mentioned before, like different member state countries,
Sure.
they have freedom to implement certain sections differently than others. With the GDPR, I think this caused a fair bit of
Yeah.
confusion.
Agree. Agree.
And I think it's probably doing the same with DORA. Is this something you can elaborate on? Like what kind of
Yeah, I,
problems do
I I think it's a bit of a suck it and see situation. It's almost like we don't know yet because it's the first day of of supervision, not enactment. But I think let's wait with bated breath. I think perhaps competent authorities will probably correlate to or look back at GDPR and look at those issues and perhaps try to avoid those. I think we might see some test cases where big companies are, or sort of large companies that can afford the bigger fines are actually kind of scrutinized more closely to start with in a breach scenario or in a scenario where there is an infringement of the law. I think it's one of those things that I'd almost say to anyone, don't try and game the system. Don't try and game it. Don't try and hedge your bets. Don't think, well, some people might say, oh, the ICO in this country or that country, they don't do anything about it. Well, don't let you be the example that they do, right? So
Mhm.
it can be an expensive kind of gamble to take. And I think all I'd say with DORA is that I think it's a new legislation. I think you will have new competent authorities that haven't regulated in that way, which will be very much kind of wanting to cut their teeth in terms of showing their teeth, if you like, as a regulator. And I think you'll probably get some early sort of enforcement action, I think, which will set the standard and probably set the scope. But like you say, derogations in law, I think it's one of those things, isn't it, that each jurisdiction can kind of almost sort of not pervert the actual law, but it does unshape it. It does sort of take away key parts of the act or the application of it. So I
Yeah.
think it's one of those things that we'll probably wait and see on. So then,
Yeah. Yeah, no, of course, I think we're also due for a little bit of uncertainty, right?
for sure.
Under the GDPR, and I think there's so many analogies. So, like under the GDPR, what we also saw is like in the beginning, let's wait for some
Yeah,
guidance from the
yeah.
regulator. Let's wait for some court cases. Let's wait for some enforcement cases so we get more, real world guidance of what is okay and what is not okay. Now, I think DORA is probably less ambiguous than the GDPR.
Yeah, it's very
Correct me if
prescriptive.
I'm wrong, but that's my
No, it's
interpretation.
hugely prescriptive, much more prescriptive than GDPR. So very much. So the RTSs, you'll see that for sort of banded around when people talk about DORA. So regulatory technical standards are the prescribed standards of what you must do in certain situations and in certain scenarios. So RTS is regulatory technical standards, and they really sort of supplement the act. Really, they are the act. They are what you must do. They are the doing points. They are when you come to your gap analysis. If you're not pointed towards the regulatory technical standards, you haven't really got a gap analysis because you're not assessing it against the standards that are mandated. We could probably move on about sort of gap analysis, but really, it's very detailed. It's very prescriptive, and those things probably are. And this is where there's a difference between privacy, data protection, and IT. I mean, IT is long been quite a binary sort of a
Mhm.
discipline. It's yes or no. It's this or that. Whereas sometimes with data protection, it's a judgment call, right? It's risk based, and you're kind of having to apply a judgment. So, are we a processor or controller in this scenario? Are we? Is this a breach work that we need to report? So it's a judgment criteria. Whereas IT is very much kind of this or that. It's white or black, right?
It's definitely more prescriptive in that sense. So that is of course a given, right? So maybe then also for the oncoming guidance, it's not going to be so much of a surprise as it was under GDPR, or do you think there will
Probably,
still?
I think there's probably be some surprises there, like country specific surprises. I think it probably will differ in terms of content and quality. I think around different countries. So the European authorities will put out their guidance, but then there'll be national competent authority guidance as well to supplement that around the derogations and that sort of thing. So yeah, wait and see. I think it's one of those things. I think from today, I'd like the message. I think is get on and do something. Right. If you're not doing anything now, make sure you do something from here on, from this day on,
Mhm.
from this webinar on. You have that conversation with your board, or you are the board, and you go, okay, we need to do something now. Right, we need to talk to their directors. We have a meeting to make sure that we understand how this might affect the organization, and also we need to know if we're in scope. Do we need to do a gap analysis, and all those very good things. So I think it's very good. We're talking on the day that it starts being supervised, Silvan. I think it's quite momentous, and I think really it's a call to action. Really, I think it's kind of one of the
Mhm.
things that people need to understand is. this isn't just another webinar about something, right? This affects your company. If you're logged into this and you're in one of those sectors that's affected, or you supply into those sectors, you need to start thinking about not just thinking about doing something. You need to start doing something now.
Right. Maybe one last point on the regulatory oversight. So
Sure.
from my understanding, there's a good level of overlap also with enforcement on GDPR, for example. It could very well be that a breach is triggering both, right?
Sure.
Uh,
Sure.
maybe there's a personal data breach, but also a breach under DORA. And I think in that point in time, we'll probably see that there is some collaboration required between data protection authorities and the authority that is overseeing DORA compliance. How do you see this happening?
Yeah, I think you're absolutely right. I think, I mean, intercooperation between DPAs happens anyway, but between countries, so that happens. That's I've experienced that as a regulator. Different countries, different breaches. So that interoperability does happen, but we're talking different regimes now, and I think
Mhm.
most certainly a regulator that's notified of a personal data breach before the personal data regulator, if you like, there'll certainly be that conduit. There'll certainly be kind of a dialogue between those organisations. I think definitely their regulatory sort of roles will allow for that. Legislation will allow for that, and I think we could probably imagine, the fifth pillar, which is information sharing, kind of regulators actually kind of showing the example on that, and actually, although that's not mandatory for organisations, you would imagine that regulators will actually kind of make a point of sort of living that sort of that pillar.
Right. Maybe before we continue, I'd like to share that we have a bit of time reserved for questions. So if people have questions,
Okay,
please share them with us in the chat. We'll do our best to answer them. So yeah, very happy to take your questions as well. Meanwhile, while we wait for questions, we had an interesting prior conversation, Stuart, about like what other certifications and efforts can be leveraged to demonstrate or to help with your
sure,
DORA compliance.
sure,
And of course, like GDPR, if you're well set up for GDPR compliance, this is also going to help your DORA. But what other things are going to help your
sure.
DORA compliance?
So typically before DORA for financial institutions, companies had to pick their kind of standard, didn't they? So it was like we're ISO aligned or we're NIST 2 aligned. So actually what sort of DORA allows for is those good competency points that are met. So many of them will be in DORA. It allows you to not have to kind of go through the the work effectively of having to kind of prove that. So as long as you've got some sort of certification in that regard for that particular discipline, then you can map those competencies to your DORA requirements. So it could be that if you're very well set up and you're very well aligned to one or two perhaps IT standards that sort of correlate well to DORA standards, then you might not have as much work as another company. So certainly make sure that when you undergo your gap analysis that you have some function to do that. So you have some ability to be able to map your current good practice to the DORA standards. If you haven't got that, there are products available to sort of do that, but definitely make sure that you leverage what you do have that's good, because you will have lots that's good. You'll to a greater or lesser degree, you'll have some things that are really, hit the standards spot on. So don't think you have to do all of the work necessarily to meet the standards. Make sure you're able to map that, so you have some sort of ability to map the requirements to your own kind of current state, if you like.
Great. Yeah, because I think we've seen more and more efforts for companies to also already obtain certifications, NIST 2, ISO 27001,
Mm,
BSI, you name it. So there's a lot of work being done already.
yeah.
So So this can be mapped to DORA requirements as well.
Which a lot of DORA is about is actually unifying the standards, right? So it's about saying these are all fine,
Mhm.
these are great to have. It's similar if you were looking for GDPR compliance, right? That golden tag, which probably is never there anyway, really,
Mhm.
in essence, because you're always trying to improve, right? There's always something not that's not perfect in your framework or whatever. So what DORA does is says actually these are the standards now. You don't pick yours, you don't pick ISO, you don't pick this, you don't pick that, and actually says these are the standards you must comply to, which I think is a great thing. I think it's unifying the kind of the standards, the response, the response, a good piece of work. I think it probably set a standard for regulation in the EU going forward. I think you could expect it in different industries as well, perhaps governments.
Yeah, yeah, that was going to be my next question actually, because of course this is mostly affected, financial industry, financial service providers. But maybe it's a great template that can also be used for other industries, and it's not unlike that this is a high risk industry, so this is a great starting point. But maybe it will spread to other industries, right?
Hmm. I think that there's a danger to look at all regulation as being a burden. It's just burden, right? So it's cost, it's cost. Actually, this is about making your business more resilient to cyber threats. That's what it is.
And
It's
cyber threats are on the rise, I think that's.
exactly. So the cost of say a ransomware attack is huge. I've been there in a company, right? So I've seen it. I've seen systems go down. I've seen the operations end stop for like 8 days, which is catastrophic for a business, right? That runs every day. I've seen how bad it can be, and I think if a regulation, it's not just it's not just wanting to fine you. It's about saying actually this is about making you fit for purpose, right? Fit for what you do, and fit for the risks that your services, if they go down, these are the risks that we need to provide for. And I think it's a good thing. I think it will make companies more resilient. I think it'll make the systems more resilient and make the
Mhm.
detection more robust and reporting more robust. I don't see it as a sort of another regulation that's kind of a burden. I think it's something that I think it would be great if we'd done this 10 years ago. I think if we standardized IT resilience, I think, it would have been a great thing. I think it's something that's long overdue. I think it will happen across sectors. I think this is probably maybe a sort of test scenario. I think it will probably
Mhm.
become, if it's successful, I think it'd be EU wide for lots of sectors and governments as well.
Right. Maybe one more question from my side before we go to the questions from the audience. Um, in terms of supply chain responsibility, how much of a burden is there actually on the financial services providers that are directly affected by DORA? How far do they need to go?
Sure.
I mean, of course, they need to have what you already mentioned. They need to have the updated contracts with their service providers, with their critical service providers. But how far do they need to go beyond that? Do they need to?
I think if there's any sort of inference that they might be in scope, do a gap analysis, right? Do that determination as to whether or not you are in scope or not. So you don't necessarily have to do a full gap analysis, but do some determination, have some record to say we decided we're in or out of scope of this regulation. This is our rationale and our documented rationale. This
Mhm.
is our risk assessment for not being in scope, and have something in place, have something kind of to fall back on, if you like. I think in terms of scope, third parties, their whole business might not be in scope. So unlike if you're fully in scope, your whole business is in scope. So it might be an aspect of that third party that's in scope. It might be an element of their business. It might be uh, a sort of entity in a jurisdiction. It might be, oh, actually, yeah, we're in scope in France, or well, we're not out of scope in Austria. We're out of scope in because they don't provide those critical
Mhm.
services to that business. So you really need to understand how much of your business is in scope, right? So how much of your business is affected by that. If you solely supply into companies that are in scope, fully in scope, you can expect to be, you know,
But
fully
from the sorry to interrupt, from the
sure, sure.
perspective of the directly affected company, right? So financial services company. how far do they need to go in order to vet their vendors, right? Is it purely contractual, or do they actually need to go in and
It's
audit?
not a paper exercise, Sylvan. So I think if we take it, I don't want to assimilate GDPR too much with DORA because they're
Mm.
very different things. But actually, if we take it back to the early days of GDPR, it was notionary, right? So you put something in a you didn't do anything to check that. It was just it was an undertaking, right? That you put in a contract that said you must do this or mustn't do it. With DORA, it's very much audits are prescribed. So you need to put audits for, and you need to do those audits. So I think a lot of the time with GDPR, it's very much like we can do an audit or we could do an audit. We reserve the right to do an audit. Actually, with DORA, it's like we will do an audit and we'll do it on this basis. We will pay for the audit. The audit will be annual. The audit will be biennial. So
Mhm.
it's a different require. It's almost like
Much more far-reaching, isn't it?
yeah, it's taken a level up really, sort of from GDPR.
Okay. Maybe looking at audience questions, I saw one question asking about if we have any awareness about how this relates to the South African Cybercrimes Act and POPIA. And I think this is, from my limited understanding, and I have to admit, I'm not an expert for the South African region, but if you look at like the Cybercrimes Act and POPIA, the Data Protection Act in South Africa, there must be an interplay as well. But do we have any insight in how this
I
compares?
don't know, don't profess to know anything about that act. And what I say is if you supply into the EU, uh, almost like regardless of that act,
Mm.
if you're a South African company supplying to the EU to one of those companies that is within those sectors, you need to think about being partially in scope, and you are in scope. So extraterritoriality is a thing, like it is for GDPR. So you can be outside of the EU and still be in scope if you supply into the EU or you have a presence in the EU. Your head office might be in the US or whatever, or in the UK or Iceland or wherever. But actually, if you're supplying into those companies, you're likely to be in scope. So it might be that there's parallels that might, to that act, the particular act the person mentioned. It might be that there's parallels that there are parallels to UK acts which are already enacted, the Potential Regulation Authority.
Mm.
One I mentioned that they find a Chief Information Security Officer 83,000, I think, last week, 2 weeks ago. That was personal fine levied on him for something judged to be, or him or her to judged to be a sort of deficiency in their obligations personally, right? So it might be. I think that would be something that if you were looking to properly assess whether you're in scope or not, those sorts of things would factor into your gap analysis, local laws, versus European laws. Definitely, if there's any, what I say is, if there's any whiff you think you might even be touched by this, do a gap analysis. Make sure you do something that demonstrates that you've not just heard about the act, not just read about it, you've actually thought.
Yeah.
Because regulators will ask questions. If you don't do anything and it's likely, or you think, well, as a regulator, you think, well, probably you should have thought you might be in scope with that. So what did you do? If you do nothing, it's really not a good answer for a regulator.
Right, but I think in conclusion, I feel I'm not aware enough about the South African
Not the
landscape.
South African act, no, but happy to take a question and look at it offline.
Yeah. Okay. Okay. Yeah, we can definitely do that. So feel free to reach out and we can have a look at that. How much help can regulated entities expect from the regulator under DORA? Are there provisions for support that?
Yeah, I mean there are. It's a new field, so it's a new area of regulation for national banks. So
Mhm.
I would imagine that they're fully prepared to be able to start regulated by now. They would have been involved in the legislation drafting, all those sort of things anyway.
Mhm.
2 years on, you'd expect there'd be some, sort of a resource to rely upon if you're a regulated entity. I think definitely look within your own country. Don't necessarily look at the sort of EU macro level. Look at your own
Mhm.
national competent authority, your national bank. Look up their individual pages. Look at all their regulatory guidance. Look at the regulatory guidance in terms of the RTSs, the regulatory technical standards, because some of those will be derogated as well, some of those won't. Make sure you click into the right sort of reference points. I think you can expect them to be helpful. I would
Mhm.
imagine they'd be helpful. I'd expect some test cases, Sylvan. That's one thing. I'd expect some. some big hits within the first 6 months, which you just don't want to be, right? For whatever company you are, you don't want to be one of those test cases, do you?
Yeah, exactly. Well, that's yeah, how much of this regulation is coming into fruition, right? Um, which is, I mean, maybe you with that already answered the last question that I was going to ask you for today, because we're
Hold
already
on.
at the top of the hour. Um, when are we going to see the first cases? Is it going to be, days, weeks, months, years? What
I
do
think
you?
about 5:30. No, I'm joking. Um, so I think
Yeah.
who knows the appetite of each organization that undertakes regulation. Who knows what that might be. Who knows? All I'd say is don't try and game it. Don't try and game the system. Don't try and hedge your bets. Don't do as much as you can. Have those preparatory things in place. Definitely have that conversation with your board. At the very least, but if you don't do a gap analysis, go back to your board. If you are the board, have the conversation. If you're a sole member of the board, or if you've got other members of the board, have that board level meeting where you say, this is here, this is affecting us. This could cost a lot of money. This is what we need to do next. Next, we need to do a gap analysis and resource that properly. If you give it to your IT security manager to do on top of his day job, it's not going to get done properly, probably, because that guy's got or lady's got a lot to do anyway. He's got a full-time
Right.
job. Make sure you resource it properly. Make sure you understand. It might not do, but make sure you understand it could cost you a lot of money. This regulation could cost a lot of money to adhere to.
And I guess it's fair to say that if up to today the word DORA didn't appear in your board meeting minutes, then
Sure.
that's probably a bad starting point, right?
Yeah,
And
I think so. I
probably
think so. I
start to
think you
look.
might have expected your IT people to have come to you by now and sort of said, "Oh, this is
Oh,
new." Yeah, something. Someone within the organisation who works in IT, or your DPO even say, or someone, if it wasn't something that was on your radar, it should have been on someone else's. And you're playing catch up, right? So it's not like you've got a lead-in period now. You're like behind the curve now, so you're behind the ball.
It's time for action, I
Yeah,
think.
definitely. It's a call to action.
That's
Cool.
what we try to convey here. Perfect. Great. Well, Stuart, thank you so much for all
Thank
this
you.
valuable insight. Maybe to the audience, thank you so much as well. Thank you for
Yes.
watching. If you would like to explore this further with Stuart, you can. You can reach out to us through our website. We can look at doing a gap analysis, gap assessment for you, and see where you stand, and what changes need to be made within your organization to meet the requirements of DORA. And Stewart is actually for us leading this effort, so you can speak with Stewart directly in one of the meetings in that process. So if you're interested, our website is techgdpr.com, and simply reach out through there, and we'll get you started. Thanks again, Stewart. Thanks
Thank
again
you.
to everyone, and I hope this was insightful. And please don't be a stranger. Reach out, and we are very happy to talk to you. Have a good day. Have a nice weekend. Bye bye.
Thank you, everyone. Cheers.